Welcome, everybody. Excited to have you in class today. My name is Curry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And today's class is all about the civil rights movement. So we are going to meet the people of the civil rights movement today and then talk about the law and talk about the courts. So there's a lot to go through today, and we're excited about it. It's one of my favorite classes because there are so many amazing people in the civil rights movement. And we're just going to take a little bit of a snapshot in some of those people. But in the chat, as we go through today's conversation, if there's other people that we're not able to get to today or that you love to learn about in the civil rights movement, feel free to share that in the chat as well as any questions. Now, for this class today, I am with Tom Donnelly, one of our top scholars at the National Constitution Center. So Tom, you want to say hi to everybody and we'll get started?
Absolutely. Hello, everyone.
So we are here and we have a lot of questions for you, Tom, as always. And we'll start off with how do we understand and what is the civil rights movement? What is it over time in America? But at the same time, what is the 1950s and 60s civil rights movement? And what are the core constitutional arguments around that movement? And then, like I said earlier, we're going to dive into the Warren Court to tell us a little bit about the Warren Court, the civil rights era, and the legacy of the court today and how we see that. And we know a lot of that also has the conversation in future classes, but this is a great class to get your facts straight on some of the Civil Rights and Voting Rights Acts. So much to do today, Tom. Are you ready to kick us off with the big idea?
Absolutely.
Go for it.
Yeah, so I mean, the big idea here is that, in America's founding documents, the Declaration of Independence, the Constitution, even the Reconstruction Amendments passed after the Civil War, we write important promises for freedom and equality into our nation's DNA. But as we know, for many, many decades, centuries, we have not lived up to the promises of freedom and equality in our nation's creed. What we will see in our story today, though, is that the civil rights movement plays a key role in getting our nation to live up to those promises. And of course, the civil rights movement, it's not just the 1950s and 60s. It's a movement that extends back decades upon decades and even expands forward past the 1960s and beyond.
So it's almost like we're taking a little snapshot into the 1950s and 60s time period of the civil rights movement and all of the players. So Tom, when I think about this, it's this amazing chessboard of different groups and different people working on different levels of all different ages, all different backgrounds. An amazing thing that they all have in common, that they're civil rights superheroes, putting themselves in the line of fire, both mentally and physically over and over again to make change. So we're going to dive into all these groups. And I have to be honest, last class, I knew all the groups and it still felt like a lot of groups. So there's a lot of groups to go through. And I think it's so interesting how their range is as well. It's like you said, the civil rights movement goes over time. So do these groups. So why don't you introduce us and we'll kick it off with the NAACP.
Sure. Of these groups, this is the oldest of them. So it was founded in 1909. And the NAACP's charter gives its mission is to promote equality of rights and eradicate caste or race prejudice among citizens of the United States. So they're calling for equality at the ballot box, so with the vote, in access to the courts, equal education, equal employment, and they have those powerful words at the end there. They're calling for complete equality before the law. What an inspiring mission statement. And what we see here is that who are some of the key players in the NAACP? Well, on the bottom left there, you see Ida B. Wells. So she's this really amazing, important figure. She was a courageous journalist, civil rights figure. She studied white violence in the South in the late 1890s and early 1900s. This was courageous work. And a lot of what we know about white violence against African Americans during that period comes from Ida B. Wells. We also see in this group an amazing figure, W.E.B. Du Bois, one of the great African American intellectuals in American history. He was the first African American to earn a PhD at Harvard. He wrote a great history of Reconstruction called Black Reconstruction, which placed African Americans at the center of the story. And again, he was an important intellectual and civil rights activist for decades upon decades. A couple of other key figures in the NAACP, there's Mary White Ovington. So she was a suffragist and a journalist, and Moorfield Story, who was a lawyer from Boston and was the founding president of the group from 1909 to 1929.
Now, the next group we dive into, the Southern Christian Leadership Conference. This is the one that, at least in my brain, I always associate it with MLK. But there's a lot of other huge people in this group and huge players and brilliant innovation in changing rights through different tactics. That's what I think is so fascinating, is the innovation of civil disobedience that happens with these groups.
Absolutely. So yeah, the Southern Christian Leadership Conference, founded in 1954. Its big idea in many ways was tactical, focusing on nonviolent direct action. And they also had more of a national focus than a grassroots focus. I mean, the key players here, you're right, Dr. King, the most famous. It's the reason why, when I think of the civil rights movement, this is the first group that comes to mind. But we can see here other amazing figures associated with this group, including Ella Baker, who carried on this amazing 5-decade-long career in the civil rights movement. She was largely a behind-the-scenes organizer. What she really urged were two big things within the civil rights movement. One, remember the grassroots. We don't just want this movement to be top down, we want it to also be bottom up. And also, we want to make sure that the leadership in the civil rights movement, it includes women. There's not just a bunch of men leading the civil rights movement, but it's a range of voices from women to men. So that's Ella Baker. We also have some other amazing figures here. So there's Ralph Abernathy. He was a Baptist minister. He was a close friend and mentor to Dr. King. He worked with Dr. King on the Montgomery bus boycott. And he also became the president of the organization after King's tragic assassination. We also have Fred Shuttlesworth, who was a minister from Birmingham and an important ally of Dr. King. And finally, we have Bayard Rustin, who was a real trailblazer in nonviolent direct action. He was, in a way, an amazing writer. He was a theorist, but he's also a practitioner of nonviolent direct action. He taught Dr. King these core principles. But as a practical matter, Bayard Rustin, he also helped organize the Freedom Rides and the famous March on Washington in 1963.
I know, and I think the idea that he got almost nearly 1 million people into Washington, D.C. and 1 million people out of Washington, D.C. within 24 hours is unbelievable, because if they stayed there too long and overnight, the danger would be so high for them. So the strategic movement of not just the content and the ideas and the vision and the words, but also the humans, and just logistically brilliant, unbelievable. Now, the next group is the Congress for Racial Equality.
So it's formed in 1942. It has a really broad mission. It's pushing really broadly for equality. So you can see its mission statement there: to bring about equality for all people, regardless of race, creed, sex, age, disability, sexual orientation, religion, or ethnic background. So we had a question before class about how broadly did the civil rights movement sweep. There were some groups at the core of it really focused really quite broadly on the promise of equality. And so this is another group that's inspired by nonviolent direct action. And some of the key players, so who are there? There's James Farmer, who he's committed to nonviolence, and he helped organize the Freedom Ride. We have George Hauser, who was an important Methodist minister, religious leader. And then we have Bernice Fisher, who was based in Chicago, and she's also known as the godmother of the sit-in movement, which we'll talk about the sit-ins a little later in the class.
And that, I love this in these slides as well, because a lot of people call it CORE, and you'll hear them reference CORE, and this is the group that they're breaking down as well. Now, the next group, the Leadership Conference on Civil Rights.
So yeah, it's founded in 1950. Its main focus is on big national civil rights legislation. So think of the Civil Rights Act of 1964, the Voting Rights Act of 1965. LCCR plays a key role in all of the legislative strategy there, but it still plays a huge role in the civil rights community today. It's a very active and important organization. So if we're looking at its key players, who are they? Well, we have Roy Wilkins, who was active for 4 decades within the LCCR, from the 1930s all the way to the 1970s. We have A. Philip Randolph, who was a very important labor organizer within the African-American community. And then we have Arnold Aronson, who is the executive secretary of LCCR from 1850, not 1850, I write about the 1800s all the time, I always think of the 1850s, but 1950 to 1980. And he worked with Randolph to lobby FDR, and he also helped plan the March on Washington.
Fantastic. Now we dive into the, did you hit, sorry, I was typing in the chat, so excuse me if I missed this. Did you talk about Ella Baker?
We haven't gotten to SNCC yet, but yes, I did earlier. But I'll talk about her again.
I jumped too fast. Okay, so let's do the Student Nonviolent Coordinating Committee.
Absolutely. So it's known as SNCC. It's a lot easier to say than its longer name. But this organization, it really represents a changing of the generational guard in the civil rights movement. These are really, really young people pushing for change. And so it formed in April of 1960. It grew out of the beginning of the sit-in movement, which started that year. And Ella Baker, who we talked about with the Southern Christian Leadership Conference, plays a key role here in helping to form SNCC. And so here, what she tries to do is she brings these people together to form this organization. And she says, you really should have two big agenda items. One big agenda item, it's direct action. So these are things like sit-ins, but also the other key agenda item, don't forget the vote. Keep pushing for African-American voter registration. Keep pushing for legislation to protect African-American voting rights. And so here we see Baker also helped bring in a bunch of other amazing young voices into SNCC. And we don't have time to go through all of them, but these are amazing names we see in the middle there. The late John Lewis. And then also, he ends up, being such a famous figure. He was the chair of SNCC for a few years, and then would be the youngest speaker at the March on Washington. But we see other key figures like Diane Nash, Julian Bond, Stokely Carmichael, Bob Moses, Bernice Johnson Reagan, people who would just have amazing careers within the civil rights movement.
And this is a much younger group. And when you think of John Lewis and you think of him, and we're going to talk about the Selma March, he's 25 years old at the Selma March in 1965. So this is unbelievably important group, an unbelievably young group. And that's a theme of the civil rights movement, that it looks across ages. And we'll see this at different times during the visuals that we'll see today. Very different age groups, everybody fighting together for these rights. And as we kind of continue to move forward in the groups, the Committee for Equal Justice.
This is a group that's formed in 1944 by Rosa Parks and Recy Taylor. So Rosa Parks, obviously a really famous figure in the civil rights movement. Here, this organization is focusing especially on African-American women. So Rosa Parks, by this point, she's already a very active member of the civil rights community. She was the secretary of the Montgomery chapter of the NAACP, which she held for 14 years. And Recy Taylor, she grew up in the Jim Crow South in Alabama, and the two of them came together to form this committee to try to bring attention in part to violence against African-American women.
So as we dive through this, looking at all these groups and like energizing the country to make change from the ground up and the top down, I always think like this is the collective of we the people, all these individuals doing such amazing work for we the people. But the other big players in this are, the court and Congress as well. So let's dive into the court next and look a little closer at the Warren Court and their effect in this time period.
Yeah, so the Supreme Court plays an important role during this period. There's no doubt about it. The court it's known as the Warren Court. It ran from 1953 to 1969. It gets its name from Chief Justice Earl Warren, whose picture you see right here. The Warren Court is the court that brought us Brown versus Board of Education in 1954, a range of other really important landmark rulings. And one way to think about the Warren Court as we get especially into the 1960s is that it's allied in the goals, it's allied with the civil rights movement in many of its key goals. And so we see many Supreme Court decisions during this period that reinforce both what the civil rights movement is pushing for constitutionally, but also the big laws that Congress passed, the Civil Rights Act of 1964, Voting Rights Act of 1965. It's the Warren Court that will step in and say, these may be big, powerful, new civil rights laws, but they're constitutional. They're consistent with the Constitution's promise of freedom, equality, and voting rights for African Americans. The last point here, Curry, is that it's easy to forget that prior to the Warren Court, the Supreme Court often was no friend of constitutional reformers, of civil rights advocates. It's with the Warren Court and beyond where we begin to look at the Supreme Court's role and its important role that we think of today of protecting minority rights, protecting unpopular groups like African Americans were in a lot of the country in the 50s and 60s, and really stepping in to enforce constitutional protections for those who really don't get a fair shake in the political branches.
I think you're actually being nice when you say that they were not an ally with the civil rights movement before the Warren Court. I mean, there's some court periods where it's way far, like they're combative against civil rights and movement. So I think it's really important to kind of think of that. And then also, as like you said, as these laws, people are calling for these laws to change and laws to be written. Legislation is being written to do that. And the court is saying, hey, we're going to take this role and we're saying these are legitimate. They are constitutional. So all these pieces working together, this is why we study the civil rights movement. It is, a constellation of stars, but it is also all these things lining up to make it work at this period of time. So diving into that, it harkens back to lining up with the values of who we are and what we believe in, and how did the civil rights movement call upon that, and how did civil rights movement over the entire story of American history call upon the values that we set forth that we need to live up to?
Yeah, so I mean, for civil rights advocates throughout American history, not just during this period, the Declaration of Independence is an important source of inspiration and power. These famous words we see on the screen, we hold these truths to be self-evident that all men are created equal, endowed by their creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness. What we'll see is over time and all the way from the very beginning, civil rights advocates drawing on these words to try to bring about constitutional reform. This goes back to 1777 with Prince Hall, who was a free African-American in Boston, petitioning the Massachusetts legislature saying, we have this Declaration of Independence. It speaks of freedom and equality. That is not consistent with the institution of slavery in the state of Massachusetts. Get rid of it. We see it echoed in the 1800s with, for instance, with someone like a Frederick Douglass, who in his speeches and address would look back at the Constitution, would look back at the Declaration of Independence and tell his white audiences, live up to your nation's founding creed. And then we see it all the way as we get into the 20th century and the attack against Jim Crow segregation and racial discrimination. When Dr. King is sitting there at the March on Washington in 1963, he powerfully says, the Declaration of Independence, the Constitution, these are promissory notes for all Americans, not just white Americans, but all Americans. Now is the time for us to live up to the promise of freedom and equality. So this is all to say, Curry, the Declaration is this important document in part because it lays out our nation's creed and it just writes in our nation's DNA. These are the values we care most about, and it allows reformers to call upon those values, look at everyone else and say, no, you are not treating us fairly. You are not ensuring our freedoms. It says right here, this is who we are as Americans. We're committed to these values. Now you must commit to them too to be truly American.
I love that. I love the idea that it's in our DNA in the Declaration, and now we just need to tap into it and let it work. So the Macmillan class asked this great question. My students want to know how the Warren Court defined the pursuit of happiness. And I wanted to ask it why we were looking at MLK, because MLK references this idea that we are all here as equal to pursue happiness, and that promissory note of what you wrote in that document is for all of us. So is there any kind of like reference point you can connect to these big words and values in the Declaration around pursuit of happiness?
I mean, nothing springs immediately to mind. I mean, with the Warren Court, when they're deciding these cases, they're relying on the Constitution more than the Declaration of Independence. But you would say the Warren Court's commitment to things like core freedoms, like free speech, religious liberty, the rights of the accused, and also its commitment to the equal treatment of African Americans and other groups. I would imagine that Earl Warren would say that these are absolutely essential to fundamental values in America of fairness, of equality, of freedom, and ultimately of happiness.
Awesome. And that leads us really nicely to look really for a second before we get into the cases at some of the amendments that the Warren Court was leaning on and looking at, not that they weren't leaning on the entire Constitution, but just to bring to a focal point, both Congress and the courts were looking at, looking and focusing on that 14th Amendment.
Absolutely. So this is a reminder again, civil rights advocates themselves, part of what they say in the face of Jim Crow discrimination is pick up your Constitution. Is this fairness? Is it consistent with the preamble's promise of government by we the people? Is it consistent with the Reconstruction Amendment's promise to abolish slavery, protect freedom and equality, and to end racial discrimination in voting? So that's the 13th Amendment, 14th Amendment, 15th Amendment. No, of course it's not. And so as the Warren Court is hearing these arguments, the Warren Court's drawing on things like the Reconstruction Amendments, especially the 14th Amendment's promise of equality, and then the 15th Amendment's promise to ban racial discrimination in voting, these being core aspects of ensuring equal rights and equal citizenship for all Americans.
Awesome. Perfect. So we always talk about look at the Constitution, look for where the power is granted. And the civil rights activists are saying, yeah, look at the Constitution, look where the power, and then use it. Because a part of these amendments all has the enforcement clauses. So it's in there saying we should do it. And it's also saying, hey, Congress, you're given more power to actually do it. But it takes a very long time. So let's start to look at making that change. And that begins with, one of the key cases with Brown versus Board of Ed. So why don't you dive into Brown and you can jump around wherever you want from there.
Absolutely. So, I mean, this case begins with, you see right there, Linda Brown. She's a third grader. I mean, what is she arguing? She's saying, she and her parents are saying, I want to go to the school that's near my house here in Topeka, Kansas, the Sumner School. And that school says no, because we're an all-white school and we don't allow African Americans here. And so Brown versus Board of Education, it's this important challenge arguing that the 14th Amendment's equal protection of the laws, its promise of equal protection, says that school segregation requiring white students and African American students to attend separate schools, that is unconstitutional. That's what Linda Brown and her parents are arguing. What they're responding to is decades upon decades upon decades of Jim Crow laws in the South, Jim Crow segregation. It touched schools. It separated African Americans and white students in schools, but it's those, it's things like separate water fountains, separate restaurants, separate hotels, separate railway cars. It's an entire structure in place intended to create second-class citizenship for African Americans. It's also a system of violence, intimidation, and laws that are designed to keep African Americans away from the ballot box. And so what Linda Brown and her parents are doing, they're saying that an important part of being an equal citizen in American society today is an equal education. And so here we have to be able to have that in order to realize our constitutional promises under the 14th Amendment. So the Supreme Court in 1896, Curry had that slide up of Plessy v. Ferguson. And so what the Supreme Court says there is that this system of Jim Crow is constitutional. So this is where we get the idea, the doctrine of separate but equal. This is the idea that it's okay to separate the races as long as the facilities are equal. And so this is the law of the land for decades upon decades upon decades. And so it's going to be decades and decades until we get to Brown versus Board of Education. But that case itself doesn't come out of the blue. It's the effort of and strategy of, one, the civil rights movement as a whole pushing public opinion towards support for ending Jim Crow, support for schools that include both African American and white students. But it's a part of a long-term legal strategy too by the NAACP and this trio of brilliant lawyers, Thurgood Marshall, Charles Hamilton Houston, and William Hastie. Of course, Thurgood Marshall would go on to become the first African American Solicitor General of the United States. So this is the lawyer who stands up in the Supreme Court arguing on behalf of the national government. He'd also go on to become the first African American Supreme Court Justice. So that's just, but here what we see in him and Brown is that he is he is in many ways the most famous and best civil rights advocate in the 1950s. And so in Brown versus Board of Education, what the NAACP does is that they bring a series of cases before then in the decades leading up, and they try to chip away at Plessy v. Ferguson. They attack Plessy v. Ferguson in university settings, in law school settings, get the Supreme Court to say, no, it's not, segregation is not working as it's being carried out in those formats, chips away at that case law until finally they can bring the really big challenge, the one that they know is most important and most controversial, and that's trying to end school segregation. And ultimately, what does the Supreme Court say? A unanimous Supreme Court says Plessy v. Ferguson was wrong on the day it was decided. We overrule that case. The 14th Amendment's promise of equality says that both African American and white students must be allowed in the same schools. And so therefore, this system of segregation, the system of school segregation is unconstitutional. And here's what Chief Warren says. He says, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. What Warren's saying here is that even if you made the schools equal, which you never did, but even if you did, just the act of separating out white students from African American students brands those African American students with a feeling of inferiority and really does not ensure them the full promise of equality under the 14th Amendment.
And it is unbelievably powerful to read that decision. So again, we love to give homework. If you haven't, there'll be a lot of reading after this class, and we'll send it out to you in a list. But this is a powerful decision that is fantastic to read. It's unanimous, so don't worry, there's not a dissent. But 1954, it comes down, and it's not like, oh, okay, click, and society changes in our country. There is so much resistance and so much pushback. So let's begin with kind of looking at the Little Rock, and then move into these constant, continuous movement and battle for rights in schools, in homes, in voting, in all civil rights and voting rights.
Yeah, so the Supreme Court issues its decision in Brown, and white Southerners respond with what's known as massive resistance. They try to use all political and social power that they have in the South to keep the schools from desegregating. And so this activity comes to a head in 1957 in Little Rock, Arkansas. We have 9 African-American students, the Little Rock Nine, attempting to enroll at the all-white Central High School. Arkansas Governor Orval Faubus calls out troops to bar them from entering with the support of white mobs. And what happens? The national government has to step in. So it's President Eisenhower who sends 1,000 federal troops, nationalizes the Arkansas National Guard, and says, no, you are going to allow these African-American students into these schools. And Eisenhower himself gives a powerful address to the nation. Finally, and this is, again, it's sort of a reminder that when you're trying to enforce the Constitution, it often requires not just the courts, but the president and other branches of government working together to push for that constitutional change. What ultimately happens is the Warren Court steps in again to reinforce Eisenhower's actions in Cooper v. Aaron. What the Supreme Court says there is that Governor Orval Faubus, state officials, when we, the Supreme Court, speak on the Constitution, you have to listen to our orders. You may not like them, you may not agree with them, but you have to listen to them.
And I think I love this because you're laying it out perfectly. You're saying all 3 branches of government have to work together to make this change. And the other branch, we the people, are driving this change. And we see that over and over again in the action. So they're fighting it on every single level, from grassroots to nationally. So this is the laws, this is through the courts, this is through the movement, and through resistance and action. And that is such a key part of the civil rights movement, is so many people taking actions every day to push back and to show how wrong this is. So that leads us to Rosa Parks. And my favorite story about Rosa Parks getting on the bus is that she thought she was really scared, and she goes to get on the bus and she thought, think of Emmett. And she was talking about Emmett Till and the young man, the child who was killed because he was African-American in the South. And she thought, I need to have courage for Emmett and his mother, and stepped on that bus. So tell us about the Montgomery County bus boycott, how many people and how long they pushed back. This is not one in one day, one bus boycott, but so long and so much resistance going on.
Yeah, absolutely. So, I mean, we talked about a little bit of the story inside the courts. Now we're going to talk about the civil rights movement outside of the courts, on the streets, in political and social action. The Montgomery bus boycott, it brings us that famous episode of Rosa Parks refusing to give up her seat on the bus to a white passenger, protesting against segregation on the buses in Montgomery, Alabama. Now, of course, Rosa Parks herself, again, an active figure within the NAACP. This is part of a broader strategy to attack segregation in Montgomery. She's arrested, and this creates just a complete galvanizing force for the African-American community in Birmingham. They end up boycotting the buses. And you're right, Corey, it wasn't just a single day thing. The bus boycott would last for over a year.
Yeah, and so to think about it, like how many people that were taking these buses to get to their jobs, to get their kids to school, to get to the doctor, for a year walked miles and miles and miles. When you put it down, you think about this constant struggle and this constant effort. Now, another, and I was at the African American Museum not too long ago in Washington, D.C., and they have an entire section that is this counter. And it's at the Civil Rights Museum as well in Alabama. It's an amazing experience just to see it, the real thing, to sit down and to feel it. But tell us about the sit-ins.
Yeah, so it's 1960. We're seeing the beginning of student sit-ins. It begins in Greensboro, North Carolina. It would spread to other cities like Nashville and Atlanta. And as part of this movement, student activists would enter a segregated public place like a grocery counter, which you see on the screen here. They'd sit in the whites only section and they wouldn't get up. And so they'd have white crowds around them. They'd be harassed. They'd be physically assaulted. They'd be, all sorts of terrible things that you could possibly imagine. But this was part of the idea of nonviolent direct action, that we're going to target unjust laws. We're going to expose their unjustness by violating them. And we are going to act peaceably to show we are the peaceful forces. We are the forces of good. And these forces of Jim Crow are the forces of evil.
Everybody's got great questions. So that perfectly moves us to talking about violence. The freedom rides. And what are some of the freedom rides had, it's not just, crossing state lines and thinking about the Commerce Clause and saying like, okay, the court said in the 40s that you cannot have segregated buses that cross state lines. I think the case is Morgan, if I get it correctly. but they also are down there increasing voter registration. So these are all connected, these actions. And this is the student groups as well. So tell us a little bit about the Freedom Rides.
Yeah, the Freedom Rides are one of the real reminders of how much just physical courage, bodily courage, these civil rights activists had to have. So in 1961, the CORE, the Congress for Racial Equality, began to sponsor the Freedom Rides. And the idea here is that we're going to have civil rights activists, some white, some African American, get on buses and drive those buses down south and force the southern states to begin to desegregate their busing services. And so these activists, they know that once they get into the deep south, that there's not just a threat, but a likelihood of real violence. And we would see that violence throughout the Freedom Rides. But in the end, the images of white mobs crowding these buses, violently assaulting these civil rights advocates, would be beamed into television sets throughout America and begin to reshape a lot of white America's perception of what was happening in the South and how legitimate these claims of the civil rights movement truly were.
And the burning of the buses too, like they torched the buses in this, and it's unbelievably dangerous. So as we're driving from Freedom Riders, do you want to take a beat on Letter from Birmingham Jail?
Yeah, so as we get into 1963, we see the largest demonstration to date in Birmingham, Alabama. And so this brings up, again, another wave of just massive violence against the civil rights protesters. We have Bull Connor, the police commissioner, sending out his forces and having fire hoses, sneering dogs, clubs, all sorts of things attacking the civil rights protesters. This would, again, lead to a lot of coverage throughout these images would be beamed into television sets throughout the nation. But furthermore, what also happens is that Dr. King ends up getting arrested as part of these activities. And it causes him to write one of the great works in American political thought ever, his Letter from a Birmingham Jail. And what he's doing in that letter, he's doing many different things, but one of the things he's doing, he's specifically directing it to a group of moderate white ministers. And these moderate white ministers are saying, you know, Dr. King, maybe you need to cool down a little bit. We're concerned about all the violence that arises when you're demonstrating in these various areas. And King comes back and he explains, look, we've been waiting for a really long time. And what I've learned from history, what I've learned from my own experience, is that the only way to get your rights from oppressors is to act, is to force them to take seriously your claims. And so he explains why nonviolent direct action is so central to the civil rights movement. He says, by challenging these unjust laws, by having our sit-ins, by marching, by subjecting ourselves to violence and acting peaceably, by violating unjust laws lovingly, openly, accepting the formal punishment, what we're doing is we're showing the highest respect for the law, but we're also forcing everyone to take notice of our claims. We're not going to just give into inertia. We're going to spur action. We're going to create constructive conflict. And through that, hopefully, negotiation and change. And ultimately, what we want to do is we want to make sure that we have in our state and local governments and in our national government laws, actors, politicians that are willing to recognize the constitutional rights to freedom and equality that we African Americans have.
And I know we're going to fast forward pretty quickly. We jump from this major moment. I mean, you're right, amazing letter to read often is what I always say. And then go to the March on Washington in 1963. We talked about Bayard Rustin moving people in and out so amazingly. We talk about your next homework assignment. And again, we know that you probably have read this, but we read it every single year publicly at the NCC and the National Constitution Center. And I feel like I still hear new things every single year. But Tom, as we wrap up the last 2 minutes, I would love for you to tap really quickly and hit upon the Civil Rights Act of 1964 and then the Voting Rights Act of 1965 to end with Congress and Congress's actions, following up on those Reconstruction amendments.
Yeah, so absolutely. So the March on Washington in 1963 spurs, it inspires many people. It shapes public opinion. It was there to celebrate the 100th anniversary of the Emancipation Proclamation, but it didn't end the violence in the South against African Americans. Furthermore, we see John F. Kennedy himself assassinated on November 22nd, 1963. And when Lyndon Johnson becomes president, he pledges that he is going to push through a new massive piece of civil rights legislation. And again, this is a reminder that we've had the civil rights movement for years upon years upon years, decades and decades, pushing for action. We have the Constitution, which writes important protections of freedom and equality in it, which gives Congress the power to pass laws to enforce those particular protections, but ultimately would take commitments by the president, Congress, political parties, and the Supreme Court all coming together to spur massive constitutional change. With the Civil Rights Act of 1964, it's a hugely important piece of legislation that attacks racial discrimination in so many different settings: work, schools, restaurants, hotels, and it's passed under Congress's power to regulate interstate commerce, but it could also be understood as importantly linked to the promise of the Reconstruction Amendments and the powers that those amendments give to Congress to pass important civil rights laws. The Supreme Court would ultimately uphold the Civil Rights Act of 1964 in two landmark cases: Heart of Atlanta Motel versus United States and Katzenbach versus McClung. But even after winning this huge victory, the civil rights movement understood the Civil Rights Act of 1964 is great, but we need to protect the voting rights of African Americans as well. And so we see an outgrowth of activity pushing for new national voting rights legislation that would extend the promise of the 15th Amendment fully to African Americans. And it culminates in Bloody Sunday. And so this is a really important demonstration by the civil rights movement. Civil rights leaders say, if we want to get voting rights legislation through Congress, we need one big demonstration. And so they say, what we're going to do is we're going to march from Selma, Alabama to the state capitol in Montgomery, Alabama. And as soon as those 600 marchers left Selma, crossed the Edmund Pettit Bridge, they were greeted, as you see in this picture, by state troopers and just massive violence, tear gas, clubs. John Lewis, who is, of course, one of the famous marchers, would bear the scar on his head from that day, exactly right there, for the rest of his life. And once again, this is captured on national television. People are appalled. It culminates in the Voting Rights Act of 1965, passed under Congress's powers under the 14th and 15th Amendments. It ends up attacking Jim Crow laws in the context of elections, protecting African American voting rights. It also has a key provision that says that if you have a really bad track record on voting rights, what we're going to do is, if you want to change your laws, you have to come to the national government first, and we have to say yes or no. And so the Voting Rights Act is a really, really powerful, very strong piece of constitutional medicine that's giving the national government greater power in the context of voting rights to try to eliminate Jim Crow and ensure equal political participation for African Americans. The Supreme Court then, the Warren Court, steps in South Carolina versus Katzenbach and says, this may be a massively new sort of law. This may be something unlike Congress has ever done before. But yes, it's constitutional. Read your Constitution. Read the Reconstruction Amendments, the 14th, 15th Amendment. Of course it's constitutional. And you know what? It worked. It worked. We see in 1960, only 20% of eligible African-American voters are registered to vote. By 1971, the number explodes to 62%. That's 20% to 62%. At the same time, African-American elected officials quadrupled from 1,400 in 1970 to 4,900 in 1980, and doubling again by the early 1990s. And so we see here the culmination of all of this activity being two big landmark statutes. But of course, as we know, the battles over freedom and equality, they never go away in America.
And I think that is unbelievably important. And a lot of questions that we have on this class is, what about? And we understand that because this is a continuing conversation looking at civil rights, looking at the meaning of Brown versus Board of Ed and desegregation of the schools. We were having a little side conversation in the chat and the Q&A about schools being more segregated today than they are since 1970. And have we lived up to Brown versus Board of Education too? That's really kind of saying like, oh, you can do all these things to do this work, but you have to do it. So as we dive into the holiday on Monday for Dr. King, and we explore these amazing people of the civil rights movement before the 1950s, all the way through to today, we also have to continue the conversation. So we will have a voting rights class that's going to come up and really dive into pre-clearance. We'll look at Shelby v. Holder. We're going to talk more and more about the 14th Amendment. I think the 14th Amendment is actually next week. If I can ever get my weeks right, I'll be good at this. And, you know, we talk about this over and over again, but these are really important moments to look at, explore, and then have dialogues and discussions around as we move forward. So Tom, thank you so much for really helping us see the people, understand how many people, and this is just a snapshot of a few, how much work it takes by so many different levels across the national government, from the grassroots to the top, and that it's continued work to get our DNA to really shine through. So thank you very much.
Thanks, Curry.
Okay, everybody.